lot of federal regulations out there. I have been in hearings where advocates for the natural gas industry have said that all local regulation is preempted by the federal coverage. And they go on to recite something in the vicinity of 20 or 25 federal laws. I think it's important to recognize that there are a whole bunch of federal laws out there. We've highlighted a few here on the screen for you, but they're not preemptive of the entire area that local regulation might want to exist in and that planners may have a play in. So from here, what I'd like to do is just talk about, moving from the federals to the state. There are residual powers that the states have. Those might be delegated from those federal programs that I flashed a second ago, and I'm trying to catch up some time, or they might be standalone powers that the state has because of the federal government not fully occupying the field. There are state programs that many of us are working with, and many of you are working with, that deal with oil, gas, mineral rights, legislation, and regulation. Some of those are changing fairly quickly, some of those are being proposed, and some of those are being fought over. There are also indirect state programs, what I'll call other state programs that certainly have bearing on the natural gas activities that we're all interested in. Those can be state water programs, and those can go well beyond the federal water programs. Those can be state groundwater resource programs and protection programs, and I think Erica mentioned that as well. And then there can be state-specific programs that focus on regional significance or projects of regional significance that deserve particular attention. When I step back, I say, why do we just go through that state, federal, or federal, state, and local consideration? And the answer is preemption. In my mind, the two sort of most important issues that a municipality has to wrestle to the ground, or that the planners have to wrestle to the ground when dealing with the natural gas issue, is whether and to what extent preemption is real. Preemption comes in two different flavors. There's explicit, that's the easy one, where the federal or state program specifically says that it preempts any local government from operating or regulating in a particular area or a particular concern. And there's implicit. And implicit, again, comes in two flavors, I would say. One is where the state or federal program has so broadly covered the field that local regulation should not be allowed to enter into those disciplines, and there are arguments about that are ongoing today. And the other is when a local regulation is directly contradictory or in conflict with a state or federal program. And again, there are arguments about whether or not certain local ordinances are falling into that area of implicit preemption. I highlight a couple cases that you should all have available to you, and I'll run through them very quickly. The first one you see there under the older Pennsylvania Oil and Gas Act, there was a case that came up, and in that case, the court said that the local land use regulation would survive because it regulates where, not how, and the Pennsylvania Oil and Gas Act regulates how. And so the local regulation could continue to exist. Similarly, there's another case, a 2012 case in New York State that effectively was a ban, and the court in that case upheld the town's ban. It was not preempted. And from there we turn to the Robinson case in Pennsylvania, and the arguments on appeal in this case were just heard on October 17th, so we're all waiting with bated breath to see how it comes out. But in essence, that case acknowledged that Act 13 could preempt local regulation of oil and gas operations, and it went on to say it acknowledged that Act 13 could preempt local regulation of environmental issues. But ultimately, it also said that it would be unconstitutional. The law was unconstitutional by requiring each land use organization or land use ordinance to allow for natural gas activities in each of the zoning districts or areas. And so you have a real tension there, and again, a challenge as planners in the state of Pennsylvania look to draft or revise or consider ordinances in the context of that particular case and what guidance it provides. These aren't something that I should spend more time on. You've seen them all before. I will flag that a couple at the bottom of here, impact fees and exactions, financial assurances, I think run into a little bit more tough sledding in states where the oil and gas laws having already put in place financial responsibility instruments. So you may find that those run into a little more difficulty in terms of preemption. And I identify a few additional tools very quickly. You've, again, probably seen them all. The two that I would flag here, or the one that I would flag here, is most important for this short seminar, is the host community agreement. We've seen it as an extremely successful, frankly wonderful and effective tool. I would caution that you always need to be very careful about who the agreement is going to bind, what is going to happen pursuant to that agreement, and what happens if the party bound sells off its assets, and finally, what portions of it, or perhaps all of it, can be recorded on the land records to have effect above and beyond simply the parties being controlled by the agreement and signing the agreement.
Thank you very much, Earl. As a follow-up, if a community elects to more aggressively regulate, what potential assertions or claims against the regulation might a well-prepared planner anticipate?
Yeah, again, I won't repeat. I do think item 1 and item 2 are clearly, look at the enabling legislation, make sure the power is there, and second, make sure that you're drafting so that you're fairly clear that you're not preempted. The rest of these arguments, the due process argument and equal protection argument, we have certainly seen, heard, and you will hear and see that there are times when those in the industry will question whether or not they are being fairly treated, and frankly, when compared to other similar activities or comparative activities in the same community. There have been arguments, and you could anticipate or should anticipate if the regulation is aggressive, that you'll hear arguments of exclusionary zoning, that by virtue of the regulation being as aggressive as it is, it's effectively a prohibition on the activity. And lastly, that's often tied to inverse condemnation claim, where those out there who believe that they should be allowed under the local ordinance to undertake the natural gas activity are effectively saying that you've accomplished through regulation a taking, and that they aren't in a position to go forward or proceed with their activity, and therefore they're owed just compensation.
Thank you very much. Now, Colin, you drafted the oil and gas regulations for the city of Arlington, Texas. Could you please talk about how your regulations have addressed effects from shale development?
Yes, we're just going to kind of touch bases on 4 different topics: setback, noise, traffic, and site maintenance. In the city of Arlington and in the Barnett Shale in general, many municipalities have different gas well ordinances. So I'm just speaking on behalf of the city of Arlington's gas well ordinance. The setbacks limits for the city of Arlington are 600 feet from a wellhead or the area around the wellhead to a protected use. We define a protected use as a residence or a religious institution, hospital, a daycare, public, private school. From that 600 feet, that can be reduced down to 300 feet if 70% of the residents in that area, or the protected uses in that area, will sign off, and our city council will vote on that. So we have to establish a zoning area around the well site to make sure that drill sites are not being placed within that 600 to 300 foot boundary set up in our ordinance. As far as noise is concerned, we require all drilling permits to do an ambient noise study. Prior for a permit to be issued, a noise study has to be done where a company will go out and they will take an ambient reading of the surrounding area. The surrounding area will give them a good decibel level. They'll take that decibel level, and we allow them to have small increments above the normal noise level in that area, 5 decibels during the daytime, 3 decibels at night. This will allow us to try to minimize the amount of noise pollution that is produced during the drilling, the fracturing, the flowback stages that you have during the whole life of these wells. Also, we look at traffic. We do a traffic maintenance study on a lot of these sites. All the traffic studies that we do allow us to try to figure out what the best way to get rigs in and out, fracking equipment in and out, and just normal delivery trucks in and out of a pad site with doing the minimal amount of nuisance or traffic congestion for our residents. Sometimes it's difficult. Sometimes we have areas where they're having to go very close to residential areas or schools. And so in those times, we have to set up time limits for traffic where they're able to come in during early morning hours or late at night, but they're not able to come during school hours. So traffic maintenance is something that we have to be constantly looking at and inspecting to make sure that the rigs and the trucks that are coming in and out of these pad sites are using their allowed traffic route. And also site maintenance. From the moment that a pad site is construction to the time that it's in production and it's just sitting there, we have inspectors that go out and they monitor and they inspect the pad sites, not only for planning issues as walls, trees, landscaping, those types of things, but also for technical issues, going on site, looking at wellheads, looking at the tank batteries, inspecting aspects of every single inch of the pad site to make sure that not only is it staying within its legal permit, but it's also staying within a reasonable amount of nuisance to the citizens in the surrounding area. But those are just some of the normal things that we're looking at in our ordinance here in the city of Arlington. It's quite complex, it's quite large, and we do our best to regulate, but not to over-regulate at the same time.
Thanks for that, Colin. Fred, what lessons has Garfield County, Colorado learned from shale development in terms of planning for the long term?
Thanks, Sorrel. This is probably part of the key of this whole presentation is the boom, bust, and the beyond part of it. And Garfield County has reeled from massive boom and bust. We certainly had the oil shale bust in the early 80s that was extremely significant. So broadening your economic base of your community so you're not just reliant on that one industry is really the goal. Now the how-to, of course, is extremely complicated and difficult and market-driven. But for Garfield County, we have put in place what's called the Oil and Gas Mitigation Fund. You know, it's the rainy day fund. You've got the Federal Mineral Lease District. I can talk about that in a minute. We've also really tried, instead of viewing oil and gas operators as someone from the outside, we've worked hard to begin more of a collaborative spirit in planning for the future and working with them and having them work with us, and I have an example of that later. On to what this means economically, there are certainly the significant impacts to infrastructure, housing, and all of those things that we've talked about. A critical part of this, though, too, that it really should be acknowledged are the economic benefits that can come from this. And by way of example, we have a fund balance in Garfield County of over $100 million. That's a lot of money given where most of the counties in the United States are. I think we may be more solvent than the state of Colorado. But in any event, you can see here we've got 3/4 of our property tax collected come from oil and gas, 35% of our total revenue from oil and gas completely. So if that's closing in on $40 million. But we have certainly 11% of the local direct and indirect jobs are connected to oil and gas. And then, of course, these bring high wages, working, living wages. And that's critical for a lot of these areas. Of course, you've got to be able to plan, in particular, infrastructure. If you can take some of those tax dollars and begin weaving that into your system, I think that's critical. And your political boards need to be astutely aware of that. And then finally, working those relationships can also allow you to do pretty unique infrastructure projects that are outside of like a impact fee relationship that Earl was talking about. In some cases, you can